In our previous post, we discussed the theoretical side of the problem of preserving privileges during the due diligence phase of the litigation funding process. In this post, we will examine some case law that addresses that problem and that offers some suggestions about how funders and litigants can share information without waiving the attorney-client or work product privileges. In Acceleration Bay LLC v. Activision Blizzard, No. 16453 R.G.A. 2018 U.S. Dist. Lexus 21506 D. Dell, February 9, 2018, the plaintiff had negotiated a litigation financing agreement with Hamilton Capital and, during the due diligence process, shared emails and documents related to its claim, shared documents, arguing that the disclosure to Hamilton Capital had waived any privilege in the documents. The plaintiff offered multiple reasons for preserving the privilege, including the common interest privilege. The court ruled that the plaintiffs failed to meet their burden of proof of establishing a common legal interest for two reasons. 1. The documents were provided before an agreement was reached between Hamilton Capital and the plaintiff, and 2. The communications were exchanged before a litigation was filed. Thus, the court concluded that the plaintiff and Hamilton Capital could not invoke the common interest privilege because they were not allied in a common legal cause at the time the communications were made. A Pennsylvania federal district court ruled that the common interest privilege did apply when the litigant and the funder took a different approach to the due diligence process. In that case, Devon IT, Inc. v. IBM Corp. No. 10-2899, 2012 U.S. Dist. Lexus 166749 ed. Ha. September 27, 2012, the funder and litigant entered into 3 agreements in connection with the funder's due diligence process: a confidentiality agreement, a common interest agreement, and a non-disclosure agreement. The court reasoned there was no waiver of the litigant's privileges because the exchange of information with the funder occurred under controlled conditions, which were created by the 3 agreements, which specifically sought to protect confidential and privileged information. These cases demonstrate that, at a minimum, a litigant and a prospective funder should enter the due diligence process by making an agreement or agreements to identify and create specific common interests and to protect confidential and privileged information. In addition, whenever possible, it would be useful for the litigant to actually file its claim before entering the due diligence phase. This would assure that the legal claim is not a mere potentiality and can serve as the basis for creating a common legal interest. Above all, it is crucial that these steps are taken before any information or documents are shared with the funder. Confidentiality, non-disclosure, or common interest agreements that are created after the due diligence period cannot be retroactively applied. If these measures are taken, both litigants and funders will enjoy a much better chance of protecting confidential and privileged information.